decision articulated a new standard for determining whether work rules and policies unlawfully interfere with NLRA rights. It overruled Lutheran Village, and under the Lutheran Village standard, even for facially neutral work rules and policies, if the employee could reasonably construe the language of that rule as prohibiting lawful Section 7 activity, it would be deemed unlawful by the board. Utilization of this reasonably construed standard over the years led to the invalidation of a large number of facially neutral, some would argue common sense policies, and really resulted in a lot of uncertainty for employers and myriad challenges in promulgating work rules, policies, and handbook provisions. So the new standard articulated in the Boeing decision, now when the board is evaluating a facially neutral policy, rule, or handbook provision, if that rule, when reasonably interpreted, would interfere with Section 7 rights, the board will additionally examine the nature and extent of potential impact on NLRA rights and any legitimate employer justifications associated with that rule. In addition to articulating a new standard, the board also announced the creation of 3 rule categories. Now, these rule categories are not part of the test or the standard. They're simply a means to classify the results of the board's application of the new standard going forward. So Category 1 rules are rules that are lawful because either the rule, when reasonably interpreted, does not prohibit or interfere with the exercise of any NLR rights, or the potential adverse impact on protected rights is outweighed by the employer's justifications. Category 2 rules are rules that require and warrant individualized scrutiny to determine whether they would interfere with Section 7 rights, and if so, whether any potential adverse impact is outweighed by the employer justifications. And Category 3 rules are unlawful because they limit Section 7 activity and are not outweighed by any justification. What's also significant about the memo is that it serves as an important reminder as to what has not changed since the Boeing decision. Specifically, rules that ban protected concerted activity or that are promulgated directly in response to organizing or other protected activity under the Act remain unlawful. And it also makes clear that while the maintenance of a particular rule might be lawful, the application of such rules to employees who have engaged in NLRA protected conduct may violate the Act depending on the circumstances presented in a given case. So the memo really serves as an important reminder to employers to be mindful of how they apply even Category 1 rules.